we propose to discuss the concept of rights in political theory today. Now, rights is a term which is very popular. Everybody in our life always claim that this is my right, we must fight for it. So, rights, everywhere this discussion going on. In political theory, what it exactly means, we start with this. So, naturally, I propose to discuss the concept of rights, first to indicate its origins, then what is its meaning as used in the political theory, and thirdly, what is its nature. Then I think the concept of right will be very clear. To start with, the reference to the concept of rights we find in Greek and Roman political thought. But it was just a reference in the sense that what the citizens expects from the society or the state, but it was not very much elaborated. But it was only during the medieval European political thought that we find the first major attempt of explaining in full form what the concept of rights implies. And its theorization was fully developed in the 17th and 18th century Western Europe. All these discourses mainly veered around the concept of natural rights. In respect of natural rights, this is the starting point in a sense. By sir, natural, yes.
Sir, can you please explain the term natural rights?
Yeah, that is exactly what I am going to do.
Yes.
Natural rights means the rights, that is, claims of the individual or society or the state. So, natural rights means, as it was used mainly during the medieval and mostly in the 17th and 18th century, that it was conceived as basically a moral right. What the nature of man or the nature with capital N, that is, to some authority, it was almost synonymous with God. That is what we can expect from the morality of man to make man more responsive to the needs of the society, and the society is more careful about protecting the interest of the individual and the groups. So that was conceived as a natural right as such. To start with, in the history of political thought, we find like this, that first concept of right comes in the form of natural right. So many people, theorists or philosophers, they claim that natural right is the basic right which human beings can claim from their very birth, or from the essence of their life. They are entitled to something which will make their nature more perfect. That is, more contributing to the development of his or her personality as well as the good of the community.
Sir, did they specify what were exactly these natural rights?
No, it was not specific, and it cannot be specified. And that is why it was more or less, I say, basically an assumption of morality in a sense. So that was taken as the compelling force that everybody, including the sovereign, they must respect the natural right of the people. And the very concept of natural right emanates from the concept of natural law, as if God or nature, they have enunciated certain law how the individual should behave in society, including how the sovereign should behave in relation to the subjects. So in that sense, it was a natural law, and from concept of natural law comes the concept of natural rights. So when it was fully developed in the 17th and 18th century, mainly by Locke and Rousseau. So it was understood that is certain values to be accepted as fundamental, basic fundamental rights of the people. And in order to make it more compelling in implication, nature, the word nature was used, and therefore natural rights, natural law, natural compulsions, etc. Now when we come to the 20th century, we find it was more refined. And refined in the sense that now in political theory, rights basically mean the external conditions secured and guaranteed by the state for the greatest possible development of the capacities of human personality. I think now it is clear.
Yes.
When the state formulates a scheme of such development or conditions of life, it is called rights. And they proceed to determine the distribution of rights. How it among the people, among the sections, who entitled to what. Now, Harold Lasky has said that a state is known by the right it maintains. That means what kind of conditions of life are maintained by the state, that reveals the character of the state. And John Pluminetz, another great 20th century political philosopher, he put it like this: no adequate theory of the relation of consent to political obligation is possible unless it includes a consideration of the nature of rights. That is to say, that is the summum bonum, the essence of political theory, the relation between the people and the government or the state. So people have got the obligation to obey, but state has got the duty to protect certain conditions, to ensure protection of certain conditions of life, which will enable the citizens or groups of citizens to fulfill the basic conditions of their existence and develop their personality. Now that is more or less the same thing which is, in other words, Lasky was putting in his typical stylist words, that the theory of rights is the avenue to a creative view of politics. It is only through the rights that one can discover what is the content of life. Like T.H. Green, Lasky also thinks that the rights are enjoyed because they help citizen realize his best self. The state can claim obedience insofar as it serves the citizens with an adequate system of rights. And that's why from one age to another, in one historical epoch to another, the very concept of rights varies, and the connotation of rights and the number of rights, they also vary. As we have entered in the mid-20th century the theory of welfare state, now the number of rights are quite various, numerous, and now it is extended to anything that is everybody has got the right to life. It means in Locke one thing, but now it means, as the Indian Supreme Court has recently expanded the concept of right to life as guaranteed by Article 21 in our Fundamental Rights chapter, that it is not only to live physically, but to live fruitfully, that is satisfying the basic needs of life. The people are entitled to have these claims fulfilled. So it is their rights. It is true that at least two major figures in recent times, Thomas Hobbes and Jeremy Bentham, they have dismissed the concept of natural rights as bogus. And so also David Hume. They didn't believe that there could be any natural right as such. The very concept is not tenable and is not acceptable. But parallelly, we have got such philosophers as Tom Paine, John Stuart Mill, or Rousseau, who were the champions of rights, were the champions of natural right. It is the basic nature of, for example, it comes to my mind that Gokhale in India, he once said that we have got the basic natural right to liberty. We are entitled to freedom, so we must have freedom. Isn't it something like this? Same thing in every age, every society that comes like this. And similarly, right to equality. This is a fundamental right. But concept of equality is not that simple. And therefore, what is guaranteed in Indian Constitution originally, that is more or less typical bourgeois theory that everybody will have equal status in the eye of law. No. But later on it was expanded or mutilated or changed and amended in order to satisfy the needs of different types of communities, scheduled caste, scheduled tribe, etc. So then it was added that they are entitled to have equal opportunity of work in the public services. And from then again it was amended to say that certain categories of people must have the right to have their special rights, that is reservation, something like this. So it changes. Now nature, so far as the nature of rights is concerned, rights carry a meaning only in the historical experience. There cannot be any absolute concept of rights as such. A rights concept of rights in medieval period, in the late medieval or early modern period, in 20th century, they are dissimilar. They are not the same thing. It all depends upon, I have already pointed it out, on that particular historical experience as such. And therefore, the latest phase we find in political theory, that the pluralist, those who believe that sovereign power is not single but it is plural, those who demand that sovereign power of governance must be distributed among different groups in society. Now they naturally, quite naturally, I mean in the logic, in naturally here I means by natural logic, they claim the plurality of rights. There cannot be any one fixed concept of rights, there cannot be any fixed list of rights, but it must be one dynamic, developing one, and state is obliged to protect those rights in the context of the particular historical context. Lasky says that economic rights is very important because when he was writing his major work, A Grammar of Politics, that was in the 30s, so at that time economic constraint, depression, etc., they are very important, labor movements, and so he was emphasizing economic rights as a very important one which will protect the other rights also. For example, right to life will have no meaning to the poor. The right to general standard of living will have no right to the unemployed. So similarly, he says that economic rights basically protects the other general rights. And he gave the example, for example, the right to employment, right to benefits in case of industrial injuries, or right to a minimum wages. These were very important in England or in America in those days. It is also become very important now in India. We feel very much right. Right of free speech cannot be protected but enjoyed by all. If they are unemployed, what can they do in that sense? If they do not have adequate education, so right to education now is become also a fundamental right. And you can say, not in the medieval sense, you can say it is the natural rights, because very nature of man will remain undeveloped unless humans get the freedom of education. So in that say, it is expansive, the concept is expansive. That is what I mean to say. And now we come to the varieties of rights. To start with, I will say, after natural rights, this discourse. Now the first major variety is what is called the concept of legal rights. And here, Hobbes and Bentham and to some extent Buddha in France, they are very clear that there cannot be any rights without legal basis. And to some extent it is so. There can be emotional expression of different rights. For example, I remember in the old Soviet Union's constitution of 1936, they said that Soviet constitution guarantees the right to leisure. Now what does it practically mean? Or right to entertainment, or right to enjoy life. Now all these are vacuous concepts. So they are the positivists. Hobbes, Buddha and Bentham, they claim or they assert that right is only meaningful when it has a really effective legal basis. That is, command of the sovereign written down in statutory laws. That can only be the firm basis on which rights can flourish and we can understand right. So this is legal rights. Secondly, Bentham insisted that all legal rights must be codified. It must not be allowed to remain in a very unrecognizable form. It must be codified, means written down. So that is very important point. And therefore, this is the first major category, if we say variety of rights. But then came the another right, which we call civil right. That means legal rights which secure the status of citizens as citizens, status of citizenship in liberal democracy. For example, right to have a peaceful existence, right to have education, that the women must have the right to a dignified life. Even the laboring class, the marginalized class, even the children, they must be treated with dignity. So all these are pertaining to the general civil existence of man. And right to enter into contract, Locke emphasized on it. So whatever makes citizenship fruitful and really meaningful, those are called civil rights. But in the 20th century, later on, towards the late 20th century or middle of the 20th century, it was argued, and argued correctly, I think, that there is a very marginal difference between a legal right and a civil right. Because those civil rights also must have a legal basis, otherwise it is meaningless. I give one simple example from our current phase of existence in India. Very recently, you know, the law of preventing domestic violence against the women have been passed. Now, what is domestic violence? So, law must be precise. What exactly means domestic violence? Now, opinions differ. And it differs in terms of culture. In North India, in East India, among the tribals in South India, among the Hindus, among the Muslims, what is domestic violence? So, unless law is specific, the entire right is meaningless. So, in one sense, they say civil rights and legal rights, they must be taken together in order to give a full meaning to the conditions of life which will make personality creative. Next comes very significant, and there is no vagueness about it, political rights. And here first comes the right of franchise. That's a right to vote. And naturally, right to vote will also carry on or bring with it the right to be elected to public offices, to stand as a candidate. And thirdly, right to exercise political power, to have meetings, etc., demonstrations. All these are political rights, distinct from civil rights.
Yes.
Then we come to another category, say social rights. This is very recent, 20th century's contribution. A right to food. Very recent, very much being debated. Right to food, right to water, right to clean air. These are all rights. They are called down rights. Right to shelter. Supreme Court has said that it is the duty of the state, central government and the state governments to arrange shelter for the footpath dwellers. The very concept was completely unknown even 50 years ago. Then the right to Medicare. Adequate Medicare is the duty of the state to carry. It is the right of the people. Right to education, that is the RTE. has been
right to
enacted.
education.
And again, there are so many loopholes are given in the RTE. So, we conclude in the varieties of discussion that last of all, some sort of what is called the model right. That is important interest of individuals and the protection on wider moral considerations. Right to professing religion of his own choice. Not only right to religion as such, but one must also have the right, some individual may have claimed the right that I don't believe in religion, that is my right. So, matter become complicated, but society as a whole recognizes that there is some moral aspect to the whole discourse of right. That is a distinction between the standpoint of Hobbes, Bentham, Hume, that only legal rights is the only thing which means business. That is not, because legality is precise, but morality is also substantive. Morality is not vague as such. And there, last of all, there are certain rights which come by custom. You may call it customary rights. Some people in the North and West India, they are now claiming that the custom of the panchayats, they have got the rights to determine the marriage of their children.
Yes.
They will decide. But not in terms of individual philosophy, individualist philosophy. So on what ground they say that parents have got the right to decide? It is because of the custom. So customary right can also be something like this. And last of all, let me, to make the whole thing clear, sources of rights. Here I think Barker is quite correct. He says that rights, jura, he says Latin word jura meaning rights, are parts or portion of jus means right. So right means justice. Right, wrong, in that sense, justice, right, singular. But when it becomes plural, it means the claims on society and the state. So I repeat, as Barker says, that there are two basic sources of rights. One is the individual source, another is the social source. One is the legal personality with immediate ground, and other is the ultimate ground, that is social recognition. So unless there is social recognition, there is no right. There are so many laws in the statute book give us a right. Then unless there is condition, because if you say the right to right to employment, that does it mean that everybody will get the employment they are getting? Reality says something different. So if the conditions are not present, I think Barker is quite right, he says. So it is the right with capital R, meaning thereby distributive justice in the society. They determine the rights. That is what kind of claim the citizens can have on the society and the state. So rights determine right. Here also I think Barker, he says, is quite correct, that ideally a right will always be derived from both this individuality, personality, and from society. But in actual life, there is a concept, there can be a concept of quasi-right. It's a new thing both Barker has emphasized. That is, only there can be some right which has only individual personality as its source. Ideally both, two sources. But quasi-right means either individual, only individual rights. For example, he has given the example that it is the personal right in a slave society to have freedom. Individual slave says, I have got the right to become freedom. But one individual. But it can be a quasi-right if we view it from the slave owner's point of view.
Yes.
They said we have got the legal right to have our slaves. So in either of the case, when the one sense is taken, then Barker argues that it is quasi-right. So in that sense, I hope you appreciate by this time that the very discourse on rights is quite expansive, it is complicated, but at the same time quite interesting and challenging.
But there is no unitary perspective on right.
No, there cannot be like this. It is a comprehensive concept, and it is a real challenge to political philosophy and law. Okay?